Hello, I'm attorney Dan Marr from the Nashua, New Hampshire law firm of Hamblett Kerrigan, and I've been practicing law for over 36 years, approximately about 37 years in New Hampshire and about 28, 29 years in the Commonwealth of Massachusetts, licensed and practiced in both states. I'm going to be talking today about how you deal with your deceased parent's significant other in New Hampshire. So I've dealt with this for a number of years with a variety of issues. You have a situation where your parent who passes on was either divorced from your other family member, so your dad was divorced with your mom, or your mom was divorced with your dad, or they are widowed and they have a boyfriend, girlfriend, significant other that are living with them, and how you deal with that once your parent passes away. Obviously, if the house itself that they own is held in joint tenants rights survivorship under New Hampshire law, that means it goes automatically to the girlfriend or boyfriend because that's the way it's written. If it's tenants in common, his half goes to his estate and her half stays with her. So there has to be some type of, upon the death, there has to be what's called a resolution with a buyout, or you have what's called a partition action upon which the court can force the sale or the buyout by the person that's still alive from the estate, and that's what happens. Happens a lot also with living boyfriends and girlfriends that own property together. If they're married, there's the divorce procedure, but if they're not, then they have to go through a partition action if they don't agree to it. But in this situation, the estate would be dealing with that aspect of it too. One of the things that I see that happens also in these circumstances is sometimes the significant other claims common law spouse. Common law spouse, I've addressed this in much more detail in another vlog, but basically there's a statute out there that only happens upon death that common law spouse can happen in New Hampshire, and you have to be 3 years continuously living with each other, so cohabitating and acknowledging and reputed as being husband and wife. Now those are two distinct issues. One thing I've litigated before, as far as when the argument of acknowledging each other as husband and wife, I had a case where it was up in the North Country, and there was quite a bit of reputation because they had children together of them being married. They were telling everyone that they were married because they didn't want the bad reputation of being an unmarried couple and having children out of wedlock. So up in the North Country, to keep the business going, he, who was the one who passed away, was telling everyone that they were married. But the girlfriend was saying he was cheating on me, he was abusing me, and in that situation, the court agreed that they weren't acknowledging each other as husband and wife. Acknowledging each other as husband and wife isn't saying, well, there's plenty of married couples that are abusing each other and cheating on each other, so that's still can be acknowledging. No, it really means the marriage vows of most judges, that you're actually faithful to this person, you're treating them properly, and that's what it means for acknowledging. The reputation issue is also a difficult one. Again, you have to have the 3 years and one of you have to die, but the reputation issue for the common law spouse claims also is difficult because, with the exception of that situation up in the North Country, I don't have many clients that are defending in a common law spouse that they're not readily telling everyone that they're not married. It's not the scarlet letter anymore of, oh, you're living in sin. There's no living in sin anymore in 2025. So people with children together, they may be an unmarried couple, and everyone knows that they're an unmarried couple, so they're not they don't have the reputation, they're not reputed as husband and wife, and therefore you lose that claim. So it's a tough claim to raise. I've defended those cases, and I've also addressed those cases also because they sometimes are useful for, if you're able to get buy-in from everyone else for Social Security, if you can prove that you're the common law spouse, you have to meet the honest answer of the 3 years cohabitating, one of you dies, and you're truly have a reputation in the community and acknowledging each other as husband and wife, but you may not have pushback if the goal is only to get the Social Security benefits. There might not be somebody out there fighting with you in regards to that issue, so consider those issues as well. If the person that's living in the house doesn't have title to that property, and they're saying, well, look, we had we treated each other like partners in this property, you might have what's called an argument of constructive trust, and then the partition action, where the equitable issue is, do they really have some type of interest in the property? I will tell you that in general, if you're just paying what would generally be the amount that you pay for rent, that would be cohabitation expenses, and the court's not going to say that's enough. Paying a large down payment, doing some other things where there's significant improvements in the property, where it really get, and maybe some conversations that other people overheard that said that you were treating this as both of your property. You need some of that type of evidence out there. Just merely paying, if you're paying $1,000 a month on contribution to a mortgage for a 3-bedroom house that you both live in for even 20 years, the judge is more likely to say that's like rent, and you had a place to stay, and you were paying that money for the occupancy rights of that property. So that wouldn't be enough. But those are issues that I've dealt with. I'm attorney Dan Marr at Hamblett Kerrigan, Nashua, New Hampshire, and I've litigated these matters and resolved these matters also without litigation. And I'm happy to talk to you if the opportunity arises. You can also check out my weekly vlogs like this one. If you go onto nashualaw.com, that's the firm website, nashualaw.com, click to my bio, and then from that bio you can click to my weekly vlogs and look at them by topic, so you can decide if there's which ones are of interest to you, and they're all around this time period of anywhere from 5 to 7 minutes. So happy to help you if the opportunity arises. Again, Dan Marr, 603-883-5501. Thank you.